So Sandra wanted me to give some information concerning this issue with Barb and her getting, going on, I'm not sure exactly what the title is, but she's being employed by Mesquite Local News. So because this had become an issue, and I think there had been concerns expressed by a group of people, I had some initial opinions, looked at the issue. I also contacted the Attorney General, or one of the Deputy Attorney Generals. I contacted the Ethics Commission and talked about this issue with them. They confirmed, primarily the Ethics Commission confirmed my understanding. When there's a conflict of interest, because as I understand the issue, I think the concern that has been expressed is that Barb has a conflict of interest. Nevada law defines that conflict of interest very specifically. This is NRS 281A. But when there's a conflict of interest, a board member has an obligation to disclose what that conflict of interest is, and then to abstain from voting on that matter if that conflict of interest would improperly influence that person. It's actually an objective, reasonable person standard. So if a reasonable person in that position, Barb in this case, would be influenced improperly to make decisions favorable to, at least presumably favorable to that party, then there would be a conflict of interest and would be appropriate to abstain from the vote on that action. It's important to delineate that we're just talking about that specific action. We're not talking about a person serving on the board in its entirety. Anybody has the right to run for public office as long as they're qualified and they meet the minimum requirements. Conflict of interest is one portion of this. There's a couple of things in the statute that I think are important. NRS 281A states the commission must give appropriate weight and proper deference to the public policy of this state, which favors the right of a public officer to perform the duties for which the public officer was elected or appointed, and to vote or otherwise act upon a matter. It goes on to say, because abstention by a public officer disrupts the normal course of representative government and deprives the public and the public officer's constituents of a voice in governmental affairs, the provisions of this section are intended to require abstention only in clear cases where the independence of judgment of a reasonable person in the officer's situation would be materially affected. The other issue I think that's been expressed is that Barb would have access to information that others wouldn't, including other reporters possibly. And this was already pointed out, but just to reiterate, the district, as everybody knows, is a public body. It's a public entity. The district's documents are available to the public. Everything that is not protected by attorney-client privilege or some other privilege is available to anybody that wants it. Reporters, citizens. We sometimes get requests from people in other states that are just looking for general information, and we honor those requests. We provide the information. The one exception to that is information that's discussed in a litigation session. Under the open meeting law, the board can meet with the district's legal counsel and discuss litigation or potential litigation. That those discussions are subject to the attorney-client privilege, and nobody other than potentially staff, management staff, and board members are allowed to attend that, whether they be reporters or otherwise. Similarly, Barb, in this case, cannot disclose any information, can't use any information, or can't otherwise take advantage of any information that's discussed in those litigation sessions. Her sole purpose of receiving that information is to be able to make decisions, and this applies to all board members, make decisions in the best interest of the district. We've talked about in a previous meeting, I think Bubba brought up the issue of these litigation sessions, what the purpose is, and we've gone over that in detail, so I won't readdress that here, but they serve an important purpose. So anyways, I think, does that primarily what you wanted me to address. Is there anything else, Sandra, that you?
The right to free speech.
The fact that why, in particular, why other media is not allowed, and you have addressed that, I believe, because she's a board member and not just media.
Yeah.
And that was one of my.
Yeah. So concerning the litigation session and who can attend, Barb is the elected official. She can attend those litigation sessions. That's part of her role as a board member, is to evaluate the information, receive information from the attorney on a litigation matter. But she was elected. These other reporters who may want to attend, they were not elected. They are not going to be making decisions concerning those issues. Nobody outside of that group can even know this information unless it becomes public information in a lawsuit or something like that. Concerning free speech, obviously everybody has the right to free speech. We all believe in that. We all hold that principle to be, if not sacred, extremely important and fundamental to our system of government. Just because someone becomes a board member, and this again applies to all board members, they don't lose their rights as private citizens. Private citizens have a right to free speech. Public officials have a right to free speech. I'm not talking about confidential information or other inappropriate information the district would have, but they certainly have a right to speak and voice their opinions. There can be consequences of seeking to improperly inhibit a public official's or targeting a public official because they hold public office and potentially bringing action against them related to their duties and carrying out their duties as public officers. And there's stiff penalties associated with that. Is there anything else you wanted me to cover?